We're here in the offices of Attorney Craig T. Conley, who is a person in Stark County who has always, in my knowledge and appreciation of him, has looked out for the rule of law, first and foremost in this county. And it's relevant to have him here today because today the Ohio Supreme Court made a ruling that goes right to the heart of that particular issue, the rule of law. And that ruling was that George Maier, who was selected by the Stark County Democrats at the beginning of this year to fulfill the term of Mike McDonald, who unfortunately could not take office because of what proved to be a terminal illness. Maier took office, was challenged immediately by Sheriff Tim Swanson, and we like to say former Sheriff Tim Swanson, but as Mr. Conley will explain to everybody as he gets into his analysis of the Supreme Court decision today that ousted Sheriff Maier from that office and restored Sheriff Swanson, that Sheriff Swanson was always sheriff and George Maier was never sheriff. Is that correct, Mr. Conley?
Yes.
So would you pick it up from there and just give us your analysis of the Supreme Court ruling today?
Well, first of all, as I often say, only half-jokingly, Supreme Court doesn't need to be right. It only needs to be the Supreme Court. But here the Supreme Court, in my opinion, was squarely correct as a matter of law. I don't think anybody of good conscience can argue that George Maier is not factually qualified. And I think he gets good reviews from the public, from government officials, and from his own deputies, certainly factually qualified. But what the court was looking at was he lawfully qualified according to the statute. And the court found, I think appropriately so, he was not on this notion of being a full-time peace officer during the immediate 4-year period prior to his appointment by the Democratic Party. It's unfortunate that the ruling took so long because there's a lot of domino effects, but it is the proper ruling, and I think even the dissent didn't necessarily say it was improper. The two dissenting justices thought maybe the statutory provision involved was unconstitutional because it was unduly restrictive. And
this was a 5-2 decision.
5-2 decision. Only needs to be a majority decision. And the court, including the United States Supreme Court, they rarely have a unanimous decision on anything. So that doesn't surprise me. But as long as it's majority, it's the law in Ohio, and like it or not, everybody is stuck with it. What I think is important now is that if I were a criminal defense attorney, one thing I'd be looking at is any deputy that George Maier swore in probably wasn't properly sworn in because George Maier was never the sheriff. Not from day one. It's inappropriate to call him the former sheriff. He was never sheriff, and Tim Swanson always was sheriff during that time period. So from a criminal defense perspective, that might open some doors for criminal defense attorneys to argue that a deputy not properly sworn in who had arrested their client or testified against their client or filed a charge against their client, that none of that's valid. That could open a real can of worms. I don't do that type of work, so I won't be looking at that issue. An issue I am concerned about is George Maier now unfortunately has to repay to the citizens of Stark County the entirety of his wages and fringe benefits, pension, health care insurance, payroll, uniform allowance, whatever's involved, because he never was the sheriff, and yet he was paid as though he were. I think he's got to give all that money back, and I think it'll be a whopping pile of dough. I also think that Mr. Maier will have to pay back to the taxpayers attorney's fees that were paid by the county for him. The theory there was the same one as in Zieglergate, that while you're a public official, you're entitled to have the prosecutor or a substitute for the prosecutor represent you. The difference between Mr. Ziegler and Mr. Maier is Mr. Ziegler actually was the treasurer, according to the Supreme Court, at all times relevant. His legal fees were paid by the county pursuant to law. Mr. Maier was never the sheriff, so he's going to have to give those monies back too. And when I get a chance, I'll be writing a taxpayer lawsuit letter to the prosecutor asking him or his substitute, because he'll recuse himself due to a conflict, to initiate litigation to retrieve those funds for the county. Bottom line, I think the decision is consistent with the rule of law. I think it's the proper decision. A little surprised there was any dissent, but Justice Pfeiffer often is a dissenter. His dissenting arguments aren't crazy, but I don't think they're valid. But it doesn't matter what I think. Majority of the Supreme Court found that George Maier's appointment was void ab initio. Didn't use that language, but that's what it means. Void from day one. He never was sheriff. Swanson always was sheriff. That raises another issue that Mr. Olson mentioned before we went on tape, that perhaps Sheriff Swanson's attorneys will now seek recovery of the legal fees he paid in defending his right to be sheriff. I think he's entitled to that. I think he's entitled to be paid attorney's fees to defend his lawful position. Haven't researched it, but it makes sense to me. Certainly seems fair. It's the flip side of the coin of the Maier problem. But hopefully this can be put behind us rather quickly. I think it presents some egg on the face for Mr. Gonzalez and people who failed to listen to the prosecutor Ferraro, who happened to be right when he said, I don't think Mr. Maier's qualified. There was a steamroller over that objection, and Mr. Maier was appointed, and it turned out to be a big boondoggle for our county. Exposes our county to risk in this criminal defense arena. Cost a lot of money, and it didn't have to happen. Should have just been done right the first time.
What if your letter of demand is refused?
I'll file a taxpayer lawsuit. I've done so several times, done so successfully, and I will seek on behalf of the citizens of Stark County a recovery of those fees. I have a high level of confidence that such a lawsuit would be successful, and that Mr. Maier will have to pay everything back. He may even have the good sense, because I think he is a man of good character, he may even have the good sense to do so voluntarily without litigation. But most people, when it involves a big chunk of dough, aren't likely to do too much voluntarily. But George Maier he's a good guy. He may just say, okay, you're right, and pay the bill. But if he doesn't, and if the prosecutor or the prosecutor's substitute does not pursue the matter, I will do so in a taxpayer lawsuit.